This right here is the core of what's happening. This isn't the full "did you do it" trial. This moment is basically the court saying, are you actually the person the warrant is for? And if you are, how do we legally send you back where they want you? That's why the judge keeps repeating identity and jurisdiction. But notice the tension. Even if the underlying charge isn't being fought in this room, the judge still has to think about bond and public safety in the meantime. And when the paperwork says armed robbery, judges don't treat that like a parking ticket, because the risk calculation immediately changes.
But my primary concern is public safety. We have enough death, dismemberment, and hysteria in Harris County as it is, and I don't want any more blood on my hands. You know what I mean?
Yes, sir.
Shh. So, your lawyer is asking me to set you a bond, and I don't know, because if you're a public danger, I'm going to have a hard time doing it. Right?
Understandable, Your Honor.
Oh, Miss Chisholm's not even here.
She just jumped off because she was just up there.
May I speak, Your Honor?
Your lawyer's not here.
Okay.
So until your lawyer gets back, I'm not going to let you go. I'm going to bring you back out, but your lawyer's not here. I can't talk to you without your lawyer here. So I'll bring you back out here as soon as she gets back, and then we'll go right through the rigmarole again. Okay? Sorry. I didn't even realize she's not here. Mr. Thurman, you're back. Okay. So I told you before, two of my main concerns are, or my two main concerns are, number one, are you going to go back to the jurisdiction where you're wanted from? And number two, most importantly, are you a danger to my public? I take public, safety. It's as important as my hair. You know what I mean? It's that important, right? Because I don't want anything.
This is actually a huge procedural moment, and the judge is doing something very specific, stopping the defendant from speaking without counsel present. That's not the judge being dramatic. That's the court protecting the process, because anything said could mess with the defendant's situation later. And the vibe here is wild, because the judge's energy is already up. He's frustrated. He's locked in on safety. And then he realizes, wait, the lawyer isn't even here. So now it becomes this awkward pause where the court can't responsibly continue. Because without counsel, it's not just unfair. It can become a legal headache. You can almost feel the courtroom trying not to spin out before round two even starts.
It happened out there with my name attached to a bond. I try everything in my power to ensure that everybody's protected. And I see that you're wanted for a really serious case. It's an armed robbery, right? I mean, that's what you're wanted for. There's no denying it. That's what it says on the paperwork.
He's on lifetime probation in Michigan.
Lifetime? There's such a thing as lifetime probation?
There is.
Yes.
Whoa.
So that case, well, I'll let you do the talking.
No, he did his time and he got out, and lifetime probation out of Michigan. So that's what's happened. I believe it got.
So how on what would, aside from like a murder case,
So he was
what
charged
would garner?
twice, along with 2 armed robberies.
I wasn't charged twice for no murder.
It just shows up.
It just shows up
Oh, I was
twice.
about to say, I wasn't charged
Murder
twice.
along with armed robbery or aggravated robbery in our jurisdiction. He's placed on probation. Since that time, he's been charged in our jurisdiction with aggravated assault with a deadly weapon and felon possession of a weapon. In those, he had bond conditions when it started off, where he was ordered to have a GPS monitor. He has had multiple curfew violations on top of that noted. And so I do believe he's a safety risk, because even with literally an ankle monitor, he doesn't follow court conditions. And so I believe he is a safety and flight risk. And the fact that there was a weapon involved with multiple witnesses, some of them children, him threatening to murder them, is that I would be opposed to a bond being set. Also, it should be noted that because of the way the probation was transferred, I can't confirm, so I can't approach on it yet. But from what I see on the system is that he moved the probation to Texas, which means there's an ICA.
Okay, lifetime probation is the kind of phrase that makes everyone sit up straighter, because probation is basically the court saying you're free, but you're on a leash. Follow these conditions or you're going back. Now stack that with what's being described here. Armed robbery, multiple serious charges listed, and the claim that even with a GPS monitor there were violations. That's why you hear the prosecutor framing it as both safety risk and flight risk, because in bond decisions, the judge is weighing, will this person come back to court, and will the public be safe while they're out? And the judge's reaction, wow, tells you this is landing heavy.
But I don't have the documents, which is why I can't present them if there's an IC hold, he's ineligible for a bond because that's an IC hold. I don't have it, which is why I can't say. But if I get the document,
Interstate compact agreement.
I understand. May I speak, Your Honor?
Of course.
Okay. After we talking about the probation, I'm at the probation, the GPS curfew wise, my judge knows all that was going on. So he knows every information of why I've been late. I have evidence of why I'm late. So he knows everything that's going on with my GPS.
You're not supposed to be late.
He knows why though.
I understand
that.
that.
That's why he overlooked. He said, okay, it's fine. He said it was fine.
Quick question, is it a motion to adjudicate?
well, no, it's still an open case. It's not under probation, but you're just asking if they do a bond violation report. They did on November 1st, 2024. They filed a motion to revoke.
Oh, so it's recent.
It's very recent.
So they've
It's
not
this
heard, okay, and then so there's not been a hearing on that yet, right?
No. But that's even after they amended the order. Also, he has further bond violation reports on December 18, 2023, another one on November 28, 2023, and that's after they amended it.
This part is technical but super important. They're talking about a possible interstate compact hold situation. And the attorney is basically saying, Judge, I can't fully prove it yet because I don't have the documents, but if this hold exists, it can change bond eligibility. Translation. Sometimes it's not even about what this judge wants to do. Certain holds can legally block release, period. And notice the judge's posture here. He's listening, asking questions, trying to figure out what's verified versus what's suspected. That matters because bond decisions are supposed to be built on reliable info, not vibes. But at the same time, judges are human. If they hear armed robbery, lifetime probation, possible hold, their risk alarm goes off.
Twice. One moment. So he seems to be agreeing with this. So the fact that he has 3 violations on top of having lifetime probation and a possible ICA, obviously, I'm still opposed for him.
Why are you on lifetime probation?
That's the way they set it up, guys. I took the plea deal.
What are you on probation for?
The armed robbery conspiracy to commit armed robbery. I did 5.5 years. Came home off lifetime probation. And to continue what I'm saying, I'm a threat to, a flight risk. I can't be a flight risk. Every court that they set, I came every single time. Every court date that Michigan have set, I flew out there every single time. I knew I was getting locked up Monday. They told me that Thursday. I still showed up to court and got locked up. So there's no flight risk in this whatsoever if I'm been showing up every single time.
And you may be showing up, but at the end of the day, you continue to do what you want to do without regard to bond conditions.
And what do you mean by that, Your Honor?
Meaning that they put you a GPS monitor, and they give you a curfew.
Yes.
And you don't abide by the curfew.
I was working, Your Honor. That's why the judge has extended, because they had my probation curfew time I forgot what time it had as. But I had started my new job because I came, got locked up, lost my other job. He said, okay, the violation he's talking about, I came into court and talked to the judge and he extended my curfew. He was like, okay, we've been working. I said, yes, I have documentation of new work. So I'll show all my documentation and he said, okay. So the stuff he's mentioning violations for, they already been taken care of. So he's not stating that either. He said 2023 is, obviously I'm still free, right or wrong. I'm still free. That means he's seen all the paperwork. I came with legit paperwork.
This is the classic courtroom clash. The defendant is arguing, I show up, so I'm not a flight risk, while the court side is arguing, you might show up, but you don't follow conditions. And legally, those are 2 different buckets. Flight risk is about disappearing. Non-compliance is about ignoring rules while you're out. Curfews, monitoring, restrictions, court orders. The judge is basically saying, even if you return to court dates, you're still treating bond terms like suggestions. And then the defendant fires back with the real-life angle. Work schedules, job loss, trying to stay afloat. So here's the question for you watching. Do you think showing up to court should outweigh condition violations? Or do violations automatically prove you can't be trusted on bond?
And that's kind of where I was coming from at it. If it's a lifetime probation and it's curfew violations that he's still out, my speculation would be that he was able to make an explanation to the judge and that's why he's not been revoked. So he's still here. As to the underlying charge, it's still a charge and that's what it is. Like he said, he turned himself in on Thursday knowing that he was going to get arrested and held. And so I'm sure that Michigan it's a probation violation because of the underlying charges. And plus that's where that MRP is probably coming from. I believe he's proven time and time again that he's gone to Michigan, taking care of what he needs to take care of, and he will still be here to take. He's been on bond on the underlying case for about a year, Your Honor. He's not been locked up this whole time up until this recent arrest. So, and at this point in time, this is really just for if since we don't have proof of an ICA, if the judge is willing to set a bond, how much that would be, if there's a willingness to set a bond.
Let me read this to you.
Yes, Judge.
Texas Code of Criminal Procedure 17.03. NLR, out of state Michigan, armed robbery, armed robbery with a conspiracy, 2021. Probation transferred to Texas 3/2021. Concurrently charged with murder, which was dismissed. No holds. Defendant is not indigent, and defendant is alleged to have gone to complaining witness's home and pointed at a gun at complaining witness and complaining witness's 3 children because one of the complaining witness's children was involved in a dispute with defendant's sister at the child's school. Defendant threatened to kill, quote unquote, everyone in the home. Defendant then left complaining witness's home and came back with defendant's father, both ready to fight complaining witness and complaining witness's wife. That's the aggravated assault that we have now. So, knowing that you're on lifetime probation for a very serious case, you know that you're supposed to be out there with a halo over your head. And yet you pick up an aggravated assault with a deadly weapon where allegedly a gun is pointed at kids. I mean, the way your mannerisms.
I would say something, Your Honor. That's why.
But don't, though. You have this open case.
Understandable.
Everything they can say, they can use it against you. My concern is public safety, man. And you got to understand that I don't know if you're guilty of this.
This is where everything gets icy. The judge starts reading the allegations out loud, and immediately you hear the warning, don't talk, open case. Anything you say can be used. That's not just a TV line, that's real. Because defendants can accidentally hurt themselves by explaining in the wrong way on the record. Also, pay attention to what the D's is doing. He's not declaring guilt here. He even says he doesn't know if you did it. But he is evaluating risk based on the seriousness of what's being alleged. And when the allegation involves kids and a weapon, the judge's whole public safety focus goes from concern to hard stop mode.
Offense or not. But the problem is bad stuff keeps happening to you for some reason. It's like sometimes people are their own worst enemy. They get out and then something happens and then they just end up picking up another charge. It's like a cold. You pick up another charge, you pick up another charge here, you pick up another charge there, you don't follow bond conditions here. Mr. Thurman, you scare me, man.
Did I scare you, Your Honor?
Yeah.
And I've been out for a whole year since this case happened, and this is my first time being into this courtroom again, and you're fearful for whose safety if I've been doing nothing but right and working.
That's not true.
That has been true. I've been out for a year on bond, and I have not been into this no courtroom, but in Orange Jumpsuit, I should say. Your courtroom, anybody's
You
courtroom.
want me to reward you for being a good
But you say you're
person?
in fear. You say you're in fear for safety. That's what I'm saying. Like, who are you in fear of? I have not been into any trouble whatsoever. I've been squeaky clean. Just I bonded out.
And Your Honor, to
You
your,
don't get rewarded for being a good person out there. You know what I mean?
I
You're
understand.
supposed to be like that anyways.
I understand that wholeheartedly, Your Honor. I'm just saying, but you say you fear, and I'm saying, how are you in fear if I've not been doing anything? That's showing you. That should show you some type of sign. Like, okay, he's never doing anything wrong. So where is the fear come to play? That's what I'm asking you.
The fear is really because, when people come here, it's little bunnies jumping in the woods, rainbows, gumdrops. And then when they get out there, they turn into different people. It's like Jekyll and Hyde. And I don't want that. Like, I don't want someone out there to suffer because we let you out. I let you bond out. You've got an armed robbery, you've got an ag assault. You continue to violate conditions on those bond right? That shows me that you're not willing to abide by bond. I mean, quite frankly, you're lucky to even be out on those charges with the ankle monitor, and you continue to violate.
And Your Honor, you keep saying violate, like, if I was in violations they have on file, by the way. Those have been taken care of. Once again, you keep on saying violations, but they took care of. The felony court judge seeing I have proven, what's the word I'm looking for? Just proven, facts that this is why I'm late. I have a new job. I got fired because I got arrested from the other job. So I started a new job. For me having a felony in my position, and just call it what it is, a young black man with a felony, it's hard for me to get a job anywhere. So the jobs I do get, I take up on those. So it's hard for any shift they open up for me, I'm going to take it and show my work ethic to them. So I let the judge know that. He sees that. He understands, like, okay, that's why you keep on bringing up violations. I have to work. I have to eat. I have to have a house to live in, like anybody else here. So you keep on bringing that up. I'll keep saying it. I already talked to the judge about it. He granted it already. He let it go. That's why I'm still free to this day. Well, was free to this day. And you keep bringing that up. You saying threat to your fear, which is understandable. Everybody gonna have fear, but I have not been into any trouble. I've been working. I've been working for a whole year. I've been on my P's and Q's. And like you said, the police report that you're reading, sir, the case is still open, so I can't really speak on it. I'm pretty say much, but it's a lot more to what you're just reading on that police report. It's always going to be video cameras and house ring cameras, body footage. It's going to be a lot more other things that you're not going to be able to read off a police report, which is understandable.
Just too much blood, Mr. Thurman. I'm sorry. I can't set you a bond. It's just too much. I'm sorry. Hey, this isn't.
Do not walk away.
This isn't.
I said, okay, it's fine.
Really, I understand that you're hurt, Mr. Thurman, but look.
I've been doing my best, Your Honor. And y'all sit here telling me I'm the bad guy, and I've been doing nothing but my best of my abilities, working, staying out of trouble. And you're a threat, and I'm a threat to society. Really? For a whole year, I've been out, and they just not issue a warrant for me just now, recently. And I come to turn myself in, and I'm a threat to society. And people, if you fear me for what? I'm turning myself in and show you that I'm not running for nothing. I'm not running for anything. I'm innocent, and I'm coming to show you I'm innocent by turning myself in. But y'all a threat. You can let go of me, sir.
Stop.
You can let go of me.
You do not tell me how to do my job.
You can let go of me. Grab my arm too tight.
Guys, relax.
I'm too tight. All I said, grab me. Look how you grabbing me up.
Back up.
Look how they grab me. I said you let me go a little bit.
You gotta calm down.
I'm calm. I just asked him a question. I asked him why she let me go a little bit, sir. That's all I said.
Open the door.
That's all I said.
And there it is, the judge's bottom line, too much blood. That phrase is doing a lot of work. He's basically saying, the combination of what's on paper, prior serious history, alleged new violence, violations, and overall risk, I can't put my name on letting you out. Then the emotional temperature spikes instantly. The defendant feels unheard, feels labeled, and starts pushing back hard, while the judge is trying to maintain control of the courtroom. This is the moment where court isn't just law, it's authority. Judges will tolerate frustration, but not chaos. And once physical handling starts and voices rise, it reinforces the judge's fear narrative, even if the defendant thinks he's just trying to speak.
Remand defendant to custody. Let me see if they give an explanation. Hold on.
Okay.
It's remand to custody, violation report, but that's not a revocation. Yeah, because
So here's what this hearing turned into. What started as an identity extradition style problem, are you the person wanted, and how do we return you, became a full risk evaluation built on the record in front of the judge. The court heard armed robbery, out of Michigan, lifetime probation, allegations tied to an aggravated assault with a deadly weapon, and repeated arguments about bond condition violations like GPS curfew issues. Even with the defense pointing out explanations and the fact that he claims to show up to court, the judge's ruling was clear. No bond set here, because the risk in the judge's view outweighed everything else. Then we learned there's an even bigger practical reality. Separate bond amounts and revocations are already in play, meaning even if a bond were granted today, there were still major barriers to release. The broader takeaway. Courts don't just look at one moment, they look at patterns. Compliance, alleged escalation, and whether releasing someone creates unacceptable danger. And emotionally, this case shows how fast frustration and perception collide in court, because how you react can become part of what the judge remembers most. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe.